Former Kogi State Governor Yahaya Bello is calling on President Bola Tinubu to intervene after the Economic and Financial Crimes Commission (EFCC) raided his home in Abuja with plans to arrest him. EFCC laid a siege by surrounding his residence, blocking traffic in the area. But the High Court sitting in Lokoja, Kogi State has restrained the Economic and Financial Crimes Commission from arresting him. Do recall that Bello, along with his nephew Ali Dauda Suleiman and Absalam Hudu, faced an amended charge before Justice James Omotosho of the Federal High Court Abuja in March 2024 regarding an alleged 84 billion naira money laundering case. All right, and today with us in the studio, we have Barrister Henry Ekine, who is a human rights lawyer, and we also have although Barrister Henry will join us virtually. We also have Dr. Gani Oluwashola, the FCTI Managing Partner, KJB Professional Services. But before we start talking with the gentleman, I will have a video of the siege to be played there. Just watch the screen. All right, that was the video, the clip we got from the resident of Yahaya Bello, the former governor of Kogi State, when the EFCC, men of the EFCC, went to his house to arrest him. Now, like I told us earlier, I have Barrister Henry Ekine, who is a human rights lawyer, and Dr. Gani Oluwashola with us in the studio. Good morning to you, Dr. Oluwashola.
Good morning, and thank you for having me.
It's good to have you. Good morning, Barrister Henry.
Good morning. Thank you for having me.
All right. Good to know we have the gentleman. Now, my question will go to you, Barrister. Here we're having a court in Kogi State restraining the EFCC from arresting the former governor of Kogi State, Yahaya Bello, and even the other people that their name came up to be part of the people that carried out this money laundering. What exactly does the court or what exactly does the law say about someone not abiding by the rule, by trying to not allow him or herself to be arrested, and also the issue of laying siege, trying to arrest the person?
Thank you. I think it's important to say something about the culture or what has become some, if you like, inheritance of our military administration in everything that we do. Nigerians will probably think that it's until you exert some level of force or some kind of, like a military disposition to doing a thing that you can actually do seamlessly, then that thing cannot be done right. That's not correct. And let's also understand the essence or the reason for arrest. What actually is it? In criminal proceeding, arrest does not add to the evidence that you need as an arresting and prosecuting authority to establish your case. But when we prioritize arrest and then would want to carry out that arrest by all means, that's when you see this kind of Gestapo or siege, and especially when the politically exposed person is involved, then you want to make a show of it. I think for me, a serious investigating, arresting, or if you like, prosecuting authority will not prioritize arrest. What you should prioritize, we should take more seriously, should be getting credible, reliable evidence for the prosecution, successful prosecution of a criminal suspect in court. To the extent that you can actually prosecute a person, bring the person to court, arraign the person without even an arrest. It is not a requirement that the person must be arrested. If we understand what actually arrest entails, it's not a requirement that the person must be arrested before he can be arraigned.
But a situation,
what about the person who is at large?
Barrister.
So, yes, please.
Sorry to interrupt you there, but a situation whereby an invitation has been made and the individual decides not to honor that invitation, what should the law enforcement agents do then?
Like I said, if the law enforcement agency had actually thoroughly investigated that allegation, and you've got credible and reliable evidence that will be able to establish a prima facie case, you can go to the courts and prefer a charge against that person. And like I said, you mustn't arrest a person to be able to commence criminal trial of that person. But it has become a sequence in this country where we even would want to arrest first before we investigate. It is not a proper sequence. The proper sequence would even be a thorough, dispassionate investigation of any criminal allegation. It's as simple as this. You receive a complaint or a suspicion of commission of an offense, alleged commission of an offense. You carry out investigation. You may be investigating an alleged offense without probably even getting in contact with the principal offender even in that instance. You probably go around the periphery. There are people who could probably be connected with that allegation. There are instances, there are documents, there are offices, there are agencies. How much of the investigation have you carried out? But because we rely more, I tell you as a criminal defense lawyer, sometimes when you go to court, what the prosecuting officer, or perhaps even the investigating police officer who may have come to testify about his investigation, the much of what he will rely on when he says he investigated a criminal allegation will be the statement of parties that he probably extracted in his police station. That is not really an investigation per se, that this person told you whatever he knew about an offense in court or in your office. So if we do not prioritize arrest, then I think we will not even celebrate all of these kind of siege, or even have situations where we report this. So let me put it in context. If you have any suspicion of money laundering or any financial crime, investigate it thoroughly. You probably will even come around great proportion of evidence, credible and reliable, that you prosecute the person. Who says that you cannot approach the court even when the person is not available? What about those that they probably, when they go to arraign a few of the suspects that you have got in custody, and say the other ones are at large? That person will show up. Then it is then you will get the order of court. At that time, it becomes an order of court, probably a bench warrant, issued for that person to appear in court to defend the allegation against the person.
Okay, now to you, Dr. Ganiu. Okay, I don't mean to cut you, okay? I don't mean to cut you, Barrister Henry, but to you now, Dr. Ganiu, EFCC and other financial or people or other anti-graft agency that were formed over 22 years ago by Obasanjo, they have the term that they use. They say that their establishment actually was to have effective, effectual, and efficient way in a professional way of cabinet to fight corruption. But we've seen the EFCC many times laying siege in people's houses. For example, it happened to former governor of Imo State, Rochas Okorocha. They were even breaking the house to enter to be able to, apprehend him. Do you now think that EFCC actually are being efficient, effectual, and even effective in carrying out the activities of their...
Yeah. Oh, you could see that in every transactions and in every operations, there are rules of engagement. And when you look at it, in the first stage, the question is that are they invited in for interrogation, for even a discussion? Did he turn up? No. You will also agree with me that this man, when he was in power, he speaks as if the whole world is under his feet. He talks with the both sides of his mouth, right? As if nothing can happen. They are both every high and mighty. And this is a man that is now in his house, and they invited you. They served you a notice of arrest, but you didn't go. Look at, we talked about Fayose. When Fayose was in office, he told the AFCC that they should relax. If he resigned today, if he hands over power today, the next day is coming to meet them in Abuja. And the gentleman turned in. And he walked out from there. You see, if you have nothing to hide, why it's even an insult to him. They're whisking you out as if you are like a goal or something, just trying to... Criminal. You understand, like a criminal. And they think it's an honor. It's even an eyesore. Ododo, you are a sitting governor of Kogi State and you hire talked. Who does that? You are a governor. You are expected to be decent, to be decorum, to have some level of decorum, right? And as a governor, you hire talk. Right? And also, not only talk, you could see a lot of things. our military, our policemen, it's just like there are now an handshake between the policeman and the thug. Imagine you are taking thug and policeman to go and rescue someone. It's not that you are going to rescue a bandit. All right, you are going there, and then you look at EFCC. They are government agency. The policemen, the government agent, right?
So
the federal, and both of them, there was a clash, right? So there is a clash. Do you know that there would have been a deadly stuff there if actually the EFCC they wield gun? Because they are not permitted to carry gun. The police are carrying gun, so they need to shoot. If it's another military or someone that are there, there will be a kind of rancor there.
Now, do you think this goes to buttress the argument? I'm deviating a little bit now. Do you think this goes to buttress the argument of state policing with the governors taking advantage of it? Because we saw that in this case, two government agencies were basically at loggerheads over an individual.
So you could now see that the reason why state policing is being discouraged hitherto is because a lot of people in power, they will use them for their selfish advantage. So they will use it in a way even to oppress their opponent and to shut them down permanently. Because they will use it because they wield the power. And do not forget, if that pays the piper, dictates the tune.
All right, then let's come back to Barrister Ikine now. Barrister, what is the situation in when a court of law gives a judgment and says, okay, EFCC and its agents should not harass an individual, but you know this was done while he was still governor of the state. And now there is another court invitation asking that he makes himself available. And we've had other lawyers say, look, the court cannot prevent the EFCC from carrying out its duties. What's your stance on this, really? There seems to be a conflicting judgment from the court of law in Nigeria.
Yeah, yes, thank you. Let me take from the point of the powers of the arresting authorities and state agents that we have. They are statutory powers, and then those powers are derived from the Constitution of the Federal Republic of Nigeria, particularly the police, which is established under the Constitution, and then further established by the Police Act 2020. And then all the other security agencies have their respective establishment acts that vest power to investigate criminal allegation and then to arrest and to prosecute those that have prosecutorial powers. So there is no reasonable justification for a court to restrain any arresting and prosecuting authority from carrying out a statutory duty, but that's a duty that's established by law. So that's usually not the case. Now, if that happens, then of course it would be some sort of an order or judgment of court that will really make the talking point, not quite for the good reason. But in certain circumstances where substantive matters subsist in a court, there may be reasons to grant ex parte applications, or if you like, prayers, for certain reasons to preserve a subject matter or to avoid interference of the proceedings of court. In some cases, that is where you hear these orders that may probably attempt to restrain any of the parties in a matter that's already before the court from taking one step or another. So you find a situation where maybe a matter is already subsisting in court, and then a party in the court in the matter reports to the court that is being harassed and intimidated and probably disturbed, even while the matter is subsisting. Of course, the court will reasonably ask every party to hold on until the matter is determined. So such orders are usually the interim, what you call ex parte orders, and they are not for a lifetime. They are not even up to the period of determination of that matter. But having said that, the disturbing thing is these days. That is why the NJC and of course commentators have actually cautioned in granting ex parte applications, especially in the manner that sometimes we experience, which is quite embarrassing to the judiciary, where you don't seem to deeply or dispassionately consider the affidavit in support of that ex parte application, and even imagine the implication of the order you want to make, where we make orders that will restrain even the institutions of government that have powers to carry out certain functions not to carry out. We have that experience even in Rivers State, where we still talk about a certain perpetual injunction that will restrain the EFCC from investigating public funds with respect to Rivers State. That's quite unfortunate to have had that experience. And then where you have a situation like the one we are talking about now in Kogi State, that a court in Kogi State will restrain the EFCC from arresting or harassing, or yes, it may appear justifiable, because it's not expected that any arresting authority should harass anybody, should intimidate anybody. So when you see on the face of those orders, don't harass, don't intimidate, don't embarrass, or that could be understandable. But to say don't arrest, so what if there is a justifiable ground for an arresting authority to arrest a person? And that's why you cannot have a court to order any investigating authority not to investigate a criminal suspect, or any prosecuting authority not to prosecute any criminal suspect, because you cannot restrain those statutory functions of those agencies. So I think it's a mix of what we really need to understand what exactly it is, and then what the order really is. If it is an order not to prosecute, then that would be absolutely wrong. An order not to arrest, where the arresting authority has the statutory power to do so, that would be wrong. But when you see certain orders not to harass, not to intimidate, of course, even the Constitution guarantees a right to every citizen to dignity of his person, not to be harassed, not to be intimidated. And so that's why I made the point that we must not emphasize arrest. As a matter of fact, if you're not emphasizing arrest, then you will not imagine harassment and intimidation.
Do we not tag this intimidation, whereby the arresting agency have come to pick an individual, and the individual locks his doors and says, "I'm not coming out"? Is that now intimidation? If they start to try to hammer on the door or try to find a way to gain entrance, would that be tagged intimidation?
Not in all cases. It will have to be a matter of fact, and depending on the circumstance of every particular matter. Because that an arresting authority is also exercising that statutory power to arrest, has come to arrest you, it doesn't mean that it's outrightly intimidation. If you have if there is no suspicion of commission of an offense, if there is no allegation, maybe by a third party, of commission of an offense, I don't think an arresting authority will just come on your own. And like the guest in the studio has mentioned, if you have been invited and then an invitation has been extended to you, why not show up? If you show up, you won't have all these display of Gestapo and then some sort of, if you like, taking siege of a criminal suspect's residence or even office or anywhere in that regard. So sometimes you find a situation where, especially politically, as we speak, arrests are going on. As we speak, I have clients who were arrested yesterday, but you don't see this siege. So these politically exposed persons, they have perhaps another reason for refusing to turn in, and then sometimes even the arresting authorities. What am I seeing on your screens? Why all of this? And sometimes it is this way because these politically exposed persons have also surrounded themselves with another set of state agents. So you now see a show of probably some sort of drama. They are not joking with us, Nigerians. Otherwise, the individual who has served as a governor and is no longer a governor, doesn't have immunity. Why would we have that great number of catcher or security men still around him? What is his statutory entitlement? Is it 1 or 2 or 3 policemen? Even if there are, even if he has, if you like, a complete division surrounding him, it's a matter of communication. Why wouldn't the head of the team of the EFCC communicate with definitely there will be a division that those officers have come from, or the commissioner, and tell them we need this person.
All right.
So sometimes they act this drama to just deceive us and then probably get us talking.
Well, interesting. I'm going to come to you, Dr. Ganiu. It's almost certain, right? As it stands, former Governor Yahaya Bello have been charged by the EFCC, of course, invited by the EFCC. Let's say maybe because of total information, he did not respond to that invitation. 17 amended charges on misappropriation of over 84 billion naira of public funds. Now, yesterday as well, the present governor, Ododo, went to Abuja with his own security agencies, of course, like we've mentioned before now, and of course, moved away Yahaya Bello from the residence in Abuja. Now, my question is, Yahaya Bello has gotten an order from court not to be arrested with a statement that I'm trying to find interesting, indefinitely. Does that speak to the fact that Yahaya Bello also called on presidency to checkmate EFCC from not obeying court orders? Does that look like something from the top, like the presidency giving a major backing for Yahaya Bello to go scot-free on all of these allegations?
Okay, that's a good and beautiful question. Let's even look at EFCC is like an example of FBI, right? And will an FBI invite you and you'll be resisting arrest? You see, it's even a show of shame at the global space, right? A government agency is inviting you, right? And you know, it does not even speak well of us. An FBI invites you and you are resisting arrest.
It's not a first. It's not a first. We've seen this play out with Dino.
Milai. Even Rochas. They need to go ahead to remove his roof and the man lie down praying. You understand? Releasing dog. You know, these are, you know, if you have nothing to hide, you don't need to run away or to try to avert arrest. And even what the court did, it's also wrong. This is in the banking sector, they call it aiding and abetting.
So
this is collusion.
That's how you see it.
Yes. Why will you say that they should not arrest indefinitely? What kind of judgment is that?
Pending when
we talk about prima facie, saying that, oh, for me to come like this, I have an evidence. There's a perception. Look at, they've thrown it at 84 billion public fund. So this money is not your own. You are there to be able to protect public fund and use it judiciously. So if you have nothing to hide, this is what we've been saying over and over again. We talk about accountability. Even living government, you should be able to account that these are the funds that comes to me. This is how I spend it. So if you have it lined out, line by line, once they invite you, you just need to excuse me, take your records along and so this is what I've done. And do you know that even public fund is one of the easiest things to do, right? It's one of the easiest things to do. In the government palace, we call it value of money audit. Okay. What they want to come and audit you, or even if they give you 100 billion, what they want to see is that, do you use this 100 billion to construct a road? Yes. Even if the road construction does not worth 100 billion, all they are looking for is that you actually constructed it and that is value of money audit. So why are you running away? And a court giving injunction that you should not be arrested.
Because actually, Yahaya Bello, according to him, was the opinion that he did not answer the call because as of February 9, 2024, a Kogi State High Court, told EFCC that they should let him be. And that was the reason.
Why would they let him be? Why would they let him be? No, that's the question. Why would they let him be?
That was the reason he believes that he has a court backing to say.
So even the man that gave that judgment, also EFCC should go after them. Well, this is what they call collusion.
Go after the judge.
This is what they call collusion. See, you are giving a judgment on something that is wrong.
Now, my question now would be, if the ex or former governors, it's happening now in Kano State, where the former governor Ganduje, he was even invited to come and account for money, even dollars, but Ganduje actually did not really, answer the call. In fact, he went ahead to say that it is only the Attorney General of the Federation.
But he's not been served. He's not been served.
No one actually has seen him to serve him.
So he hasn't been served, one.
Yes.
And two, the reason why things are turning against Ganduje is because the Yusuf there, they are not in tune. So look at APC in Kanu, they've already suspended him, right? Because they are ready to fight it. Because this guy in Kogi is trying to play the the governor's boy. I don't want to use a puppet.
Oh, yes.
No.
Right?
Where does that leave the fight of corruption in
So,
Nigeria?
you know, even if EFCC, that's why I said that if they wield weapon, they will only tell you that you will be the only one to be excused here because you are the only one that have immunity. Every other one around you does not have immunity.
The president told us that
Do
we
you get it?
cows,
So at that point in time, they should be able to separate. You are out of office. You should be able to come up and say that I didn't spend this money. This is 84 billion naira, right? And if they want to factor in inflation, they should turn it to 100 billion.
All right, let me come back to Barrister Henry Ikine. Now, what is the place of now the question I just skipped my memory. Well, what is the place of jurisdiction? Yes, jurisdiction now in all of this, because this was playing out in Abuja, the Abuja home of the former governor, and then we have the current governor Ododo rushing to Abuja. All right, maybe he was even in Abuja already, I don't know. But he had to go to the residence in Abuja when he should be administering the state in Kogi. And also, the EFCC, what is the role, and the police as well, what is the role of jurisdiction in all of this?
Thank you. First, let me express my disappointment with the manner our public officers use the privileges they have and of course abuse them. And that's the sitting governor in Kogi State. I wonder how this relates to him. I wonder how it's connected to him. Yahaya Bello is an individual, and then he can actually commit an offense. So if he has been alleged to have committed an offense, just like every other citizen of the Federal Republic of Nigeria, especially no longer having immunity that is only available to the president or the vice president and then the governor and deputy governor, he could be arrested, it can be investigated, it can be prosecuted. Now, if the governor, for whatever reason, will leave Kogi State and then go to Abuja or anywhere in that regard, whether it is in Port Harcourt or in Bayelsa, anywhere that Yahaya Bello would have been, and then if we're to go there to prevent the arrest or interfere with the arrest, then of course it's actually an abuse of the privilege he has as a governor. Even if he can't now be arrested and prosecuted, but he can't be investigated anyway. Because I know and I believe that interfering with arrest by an appropriate authority, that is an authority that has arresting, an institution of government that has arresting authority like the Efcc. If to another person that were to interfere with arrest or prevent arrest or even resist arrest, it constitutes even another offense. So I think that we must understand clearly that that kind of interference, it happened in Rivers State at some point when a certain officer of the NDDC was to be arrested, and then the former governor, while sitting as governor, interfered and all of those. The governors need to understand that that's not part of their responsibilities. And then if at all they want to consider to protect some individuals, is that how they're going to protect everybody that's going to be arrested? Is that how the Kogi State governor is going to go to interfere and protect the arrest of any other citizen of Kogi State? So I leave that. Now the issue of jurisdiction, and then I worry really why the governor will leave Kogi State and go there. But for the EFCC, the Economic and Financial Crimes Commission established by law, especially to investigate matters or allegations in relation to financial crimes, has authority that covers the entire country. So the EFCC can arrest anybody anywhere, and then can also go after anybody anywhere, provided the person is contravening any of those provisions of the law. And let me dare say again, those financial laws that the EFCC is empowered to implement and enforce, they are federal laws, whether it's the Economic and Financial Crimes Commission Establishment Act itself, where any provision is contained with respect to any criminal conduct, whether it's the Prohibition Act, whether it's the Terrorism Prevention Act, all of those laws are federal laws. So the EFCC can arrest anybody anywhere. Therefore, Yahaya Bello, especially in this instance, being in Abuja, if when you're even preferring any charge against the person or filing any civil suit against the person, the defendant, the location where the defendant, any of the defendants, if there are multiple defendants, is resident, that the court in that area or that place has jurisdiction.
Okay. All right then. Now, finally, in case my colleagues don't have any other question, you can give your concluding thoughts.
But we're pressed for time.
But yes, we are pressed for time.
We're pressed for time.
A fellow human rights lawyer, Femi Falana, is of the opinion that the Inspector General of Police, Egbetokun, should withdraw the policemen that have, that are in the residence, at the residence of Yahaya Bello, protecting him. They should be withdrawn and tried for obstruction of justice. Do you share that view, or do you have a contrary view?
Yes, excellent. I agree with him. The learned cell, and incidentally, the chairman of the board of trustees of the Committee for the Defense of Human Rights, which I am the national legal advisor, so is the chairman of the board of my organization. Yes, I agree with the learned cell, and that's the point I made earlier, to the effect that I wonder the cartel of policemen around Yahaya Bello. Let us assume that he even has the right to have one or two or whatever number. But when those police officers conduct themselves in a manner that is unlawful, preventing another state agent from carrying out statutory duty, then completely that police officer or those policemen are on illegal duty. It is not a lawful duty for a state agent to prevent another state agent from carrying out its legitimate responsibility. As a matter of fact, even if it's a policeman that is attached to me, that policeman should be able to arrest me if I'm committing an offense. In a responsible society, the police officer attached to me has not lost the primary responsibility to protect and enforce the laws, even if I am violating the laws. But we have it differently in this country. So it's a justifiable call for the Inspector General of Police to send a warning message to those purported or supposed security agents, that's the policemen that are on duty. If they are on legitimate duty around Yahaya Bello, call them to order. And that puts the question, what is Yahaya Bello running away from? As a matter of fact, I've always known that any offense is bailable. Surprisingly, even the most capital offense, including murder, if you're standing trial for murder, the law is also that bail is available to you. The only difference is that the conditions may be stiff. The special circumstances that may be required for you to establish for the court to exercise that discretion in your favor, to probably consider you granting you bail, may be stiffer special circumstances. So why will these former governors and politically exposed persons be running away from prosecution or even trial or investigation, when perhaps the allegation is even monetary offenses? It does not matter the amount of money. Whether you stole 10 billion naira, it's still bailable. Whether you are alleged to have laundered 100 billion, it's still bailable. But again, it's an opportunity for you to come and even defend yourself. Walk to the office of the arresting authority. If you like, if you want to exercise your right to remain silent, you remain silent. If you want to exercise your right to volunteer a statement, you do so.
They don't even read out your rights to you when they come to arrest you. We don't know if that's even a thing in Nigeria.
Because even your right, they have so much force to even to override your right. Because they will say, because normally, before they can arrest you, they must come with a warrant of arrest. So how many people, how many houses they've gone with a warrant of arrest? They will just hijack you and say you are going, right? And if you try to resist arrest, so they can even become forceful. They can shoot you or anything. You understand? So these are things that they should also, because some people knows their rights, right? But the question is that they're also afraid of their life. Because they've seen a lot of a shooter, a straight bullet or incidental discharge. So you would have gone, and the person would have faced it. So they just say,
I'll just come with you.
I'll go along with you. But this thing I would just try to say is that the IG itself should have even cautioned all these policemen. Immediately should have talked, right? And also called them to order not to do. You see, the 84 billion that we are talking, when you get to Kogi, their schools are in a mess. You see, my heart bleed as a governor, and you leave a place worse than it is. So these are things that also you should be able to come and make statement for yourself and say that these are my explanation. I didn't do this. And if he knows what I should have advised Ododo, he said, okay, go. I will get you a good lawyer. He can even get Barrister Henry to come and
All right then. Well, we are pressed for time. We've actually overused our time for this topic, and we'll be going into the other topic where we're still bordering on court judgments and issues within the courthouse. So, Barrister Henry, would like you to stay with us, and also Dr. Gaganiu would like you to stay as well. Now, court threatens to adjourn Nnamdi Kanu's trial indefinitely. Okay, let's talk about this one when we come back from this break.